Welcome to another edition of Podell Screencasts. Today we're going to talk about the Bill of Rights, the first 10 amendments to the United States Constitution, proposed by James Madison to the House of Representatives. Interestingly enough, James Madison proposed 12 amendments that made it out of the Congress. Of the other two, one of them was a right to conscientious objection to military service, which has never been ratified. And the 12th one that was ratified by the Congress wasn't ratified by the states until the 1990s. It's now the 27th Amendment to the Constitution, the most recent, which bars Congress the ability to raise their own pay in the middle of a session. It's also important to note that originally, while the Bill of Rights only applied to the federal government, the Equal Protection Clause and Due Process Clause of the 14th Amendment has extended them to bind the actions of the state governments and local governments as well. Now, the First Amendment to the Constitution codifies 5 big freedoms of speech, press, religion, assembly, and petition. Right? And there's 2 that we're going to examine a little bit closer here, although they all certainly demand greater time and attention than is given here. Freedom of religion, the granting of it, is monumental in the history of the United States and in global history. Great Britain at the time had an established church, the Anglican Church, the Church of England. Being a member of the Anglican Church meant that as a citizen of the kingdom, the United Kingdom, you enjoyed certain additional privileges, different tax rates and the like. So the fact that the law applied equally to you regardless of your religion, kind of a big deal. Freedom of speech deserves a little bit closer scrutiny, if for no other reason than people seem to screw up what it actually means pretty frequently. Freedom of speech does not prevent anyone from having reprisal against you for your speech. It merely prevents the government from doing so. Now, you can't perpetrate a public danger like yell fire in a crowded theater. There's certain classes of speech or kinds of speech that aren't protected, and those exceptions are carved out in Supreme Court jurisprudence. But your employer, and this is very important for those of you out there who are on the younger side watching these screencasts, just learning about the world of work, your employer does not have to endorse your speech with continued employment. The Second Amendment speaks to the right to bear arms not being infringed by the federal government. Some are often confused by the exact meaning of this amendment, though I don't necessarily understand why. No, all joking aside, not literal bear arms, but bear arms in terms of firearms. There are open questions that are up for debate in the public square about the extent to which this applies to weapons that can fire a certain number of rounds in a certain amount of time, often classified as assault weapons. That I will leave for the politicians to decide. Third Amendment, basically pretty simple one, says that the government can't make you quarter troops, keep them in your house without your consent. This was done as a response to the practice of the British during the American Revolution. The Fourth Amendment's way cooler. It protects you from unreasonable searches and seizures and requires probable cause before your things can be searched or seized. Police are required to have reasonable suspicion as carved out by jurisprudence, or more explicitly, a warrant to search and seize your stuff. Now, the Fifth Amendment has within it a certain number of guarantees as well, and most of them are involving our judicial process, the right to a grand jury to decide whether or not to post a bill of charges, the right to an attorney, the right against self-incrimination. So please never testify against yourself in a court of law. It places the burden of proof squarely on the state in order to convict you of criminal charges. Now, the Sixth Amendment has a number of judicial processes in them as well. The most important being the right to a speedy, fair, and public trial. The seventh deals with civil law. It says that you have a right to a trial by jury for all civil cases, for the grand whopping sum of 20 doll hairs. $20. Nice going. Okay, the Eighth Amendment, super important. No excessive bail fines or cruel and unusual punishment. This cruel and unusual punishment, if you're saying to yourself, hey, Podell, that sounds kind of vague, well, you'd be right. It's a shifting standard that has evolved through time. What's important here to note is that you're not bereft of your human dignity because you've been convicted of a crime. Now, one of the original opponents to the idea of including a Bill of Rights was James Madison, and Madison believed, like many Federalists, that the inclusion of a Bill of Rights might construe courts and people to believe that these were the only rights that people had. And this is what the Ninth Amendment is meant to disabuse us of, if you will. The idea here is that just because it doesn't say that there are certain rights in the Constitution doesn't mean that the people don't hold them. Now, the last amendment within the Bill of Rights, the first 10, is the 10th Amendment, and it codifies in our tradition federalism and the notion of popular sovereignty, that the people are ultimately in charge. What it states is that those powers not specifically delegated to the federal government under the Constitution are reserved by either the states or the people. Thank you so much for watching. I hope you enjoyed this screencast. Know your rights, people.